Welcome everybody back to our webinar on documentation. Today we're going to talk about documentation habits, some rules around that, and some stories around that, and the form of examples of what to do and not to do. And we're going to try to explain how companies can better, well, individuals first, but then companies better have control over what's creative, or more how it's creative and what the content of documents are or is, excuse me. I'm David Graham. I'm from Gardner Law. I litigated many medical device um, cases and drug cases. And so most of my stories come from either medical device and drug cases, False Claims Act cases, or food class action cases. Um, so the agenda today is a recap of what we did last week. Then we'll do an introduction to the rules of the road. That should just be the rules of the road, probably. Talk about bad document creation practices, good practices, some organizational avenues for reporting, and other ideas around corporate culture and integrity that can help with people's habits around document creation. And then if you have questions, please ask them, and I will try to take them from the question box in the webinar. So the first thing I want to do is recap before we go on to the subject matter for today, is kind of recap what we talked about last time, and that is we went through sort of the structure in which documents fit in a litigation, and that was privacy, confidentiality, the rules around spoliation, and that is the proper retention and destruction of documents. We didn't go into details of any of those things, but talked about having an awareness of and a plan for those things. And one I left out, mea culpa, is privacy, which is obviously important because you probably would have patient information. Even back before HIPAA and other things like that, we had to pay attention to people's personal information. There should be, in all medical device or healthcare companies, drug companies, there should be already structures in place and rules in place within the company to protect the privacy of patients' documents and other people's documents. It might even be the privacy of employees, depending on the circumstances that may be witnesses in litigation. You can't, just because somebody knows information about a particular liability issue or a fraud issue or something like that, doesn't mean their personal information is up for grabs. So remember privacy when you're thinking about document retention and document policies. And I'm sure most of the companies, or most of you listening, are well aware of the rules around that, both in the United States and Europe and other places. Paul in our law firm is a privacy expert. So if you ever have questions about that, you can talk to him. And we have plenty of people that can give you advice about that. And you may also have those within your organizations who you can talk to. So if there's ever an issue about passing on private information, that's important to keep in mind. So today we're going to talk about sort of the rules of the road and just how to avoid making bad documents. And in my mind, this comes down to sort of culture issues, habits, and discipline. So you need to view creation of documents as conduct, not just I'm writing something down and recording it. In other words, when you get to trial, the attorneys are going to make whatever you have in documents sound like the attitude or the values of the firm that they're trying a case against. So the writing is just not a a recording again. It's something that reflects what the company thinks and has done. So as you remember, as we talked about last time, a lot of it comes down to intent. Obviously, when we were talking about spoliation, intent was the thing, but it's also intent matters in cases. It can be the difference between a civil case and a criminal case. It can be the difference in how much a jury evaluates a company's level of negligence. And so intent is important, and intent can be reflected in documents in certain ways. So inartful documents, even though they weren't meant to be malicious or in any way a reflection on the person's view of the company's values, they can be read that way. So you got to think of document creation as not just recording, but conduct. And I want to remind you of this as well. When we're talking about lawsuits, oftentimes, especially with liability related to personal injury, but also with fraud cases, prosecutors and people trying to win cases against your company want to know, what did you know? That is, when did you know it? And what did you do about it? So documents go into that general architecture of a case. It seems really simple, but if you've ever sat through a deposition, and I hope you have not, but if you have, you'll know that's what they want. That's what they'll ask you about. They'll go through your documents and want to know, they'll want to create a timeline. They may have created a timeline already when they've gotten to you. And so they're going to put your documents into this timeline and try to determine what you knew and when did you know it and what did you do about it. So you got to keep that in mind when you're creating documents. Maybe not documents where you're just sending invoices to people who pay it in the firm. Maybe not documents that are just setting up meetings. But when you're especially when you're dealing with, potential recalls, complaints from consumers, maybe internal complaints, maybe FDA inspections or the aftermath of an FDA inspection where you're dealing with 483s and things like that and making a strategy around what to do with it. Or marketing, especially marketing. You need to put a little more thought into how the documents are created and how they reflect them on the company's values and what they want to project as those values to the medical community and to the public. Most companies in medical device and healthcare and food companies are set up to do good things for people. They're set up to heal them, feed them, and give therapy in some way. People aren't creating new technology, not only for profit, it actually hopefully lowers the cost of care and makes people get better faster. So a lot of times what happens in our daily business is our writing, which will be interpreted as conduct and a reflection on our values, gets to be so in the moment that we don't remember. It's not that we don't care. That's not my point, is that we kind of lose sight of the general mission of the company. That's enough of that sermon. I'll get on to the rules of the road. First is nothing's in a vacuum and you're not alone. You can write a memo to somebody or an email. Why do I say memo? I'm sorry, an email or text, and it's within the context of your employment at a company. Sometimes I think when I read documents from people and back and forth amongst employees, and it ventures not just a little outside the business goals of the company or the business purpose for which things should be written, it gets stilted. And again, this is nobody's trying to do things malicious, but you got to remember you're operating in a team context, and what you write is what the company writes. Maybe that's the better way to say it, more concisely. So even though you might not technically under the law be a representative of the company and may not be able to bind the company because you don't have the appropriate authority, it's still the company speaking. It's going to be read to juries as if the company is speaking, even though you're a person who may not have that legal authority. So when you write to achieve a business goal or advance the business and determine what you are intending to say. And if what I am saying is consistent with getting a job done for the company and completing whatever assignment I have, then that's what you should be writing. If it doesn't seem like that, it's more than that, and you're not sure about it, and it may be because of the unfamiliar or the task you've been given is unclear, but you need to clarify that. Doesn't mean you have to sit and think for 10 minutes about everything you write. Business moves fast, especially for developing companies trying to develop new products, get them approved, dealing with a budget from investors and things like that. But cutting the noise by just writing, advancing the business purposes of the company is one simple way to keep documentation under control, at least ones that might be viewed as outside the bounds of the business. Assume that someone that is not intended recipient of the communication will read it. That is, you need to write, even if the addressees are 3 specific people on a specific project, and you've been working with that group on a project, you need to assume that other people in the company are going to read it. Obviously, you probably have reporting to do. It might be investors. Things you write might be incorporated into offering documents or other documents like that. Certainly regulators might view the documents depending on what the purposes of them. And so you need to assume that even though your audience seems limited in the moment, it's not going to be. It's a company document, and therefore it won't be something that you can keep control of. Especially if litigation occurs, it's going to have to be produced to another group of lawyers on the other side of the case, and will be interpreted however they interpret them. So, and that interpretation might be being done by a person that's a recipient of the document who's now not a friend of the company. So it's important just to assume that it's a document available to the world, and assume the document will be evidence in a legal proceeding. I try to get people to just pretend like it'll be read to a judge, right? So if you read your document, your email or whatever, and it wouldn't be appropriate to read in open court or before a jury or a judge, then you better rewrite it, or at least think about it, or go talk to somebody about it. So it's important to keep in mind that it takes on a life of its own once it goes into the cloud or wherever it's stored, and it gets produced in litigation. All the context, you lose the context, possibly is a better way to put it. So terms that are not carefully chosen, or other allusions to things that might seem funny or sarcastic, or things that within the group you're communicating with seem perfectly fine, might not be. Businesses don't need to be humorless, but the humor might be better verbally than in writing. So you just have to be careful about that because of the reflection it might have on your company through the interpretation of somebody who doesn't have good thoughts about you. So, excuse me. So that's the 4th rule. The final one is probably the most obvious and maybe the most important, but gets forgotten a lot. So we're trying to build things economically, products or drugs, and we want to do it in the safest possible way. This applies to food too, and I'll give you an example where it comes into play. And we're talking about processes, manufacturing process, good manufacturing processes, and the regulatory requirements around them, And obviously the most efficient way to do it to keep the cost of our products at its lowest, but also have a very safe product. So one thing you don't want to ever do is say, we didn't employ these safety processes because they were prohibitive monetarily. Don't do that, right? There's always give and take, right? First of all, you got to remember that nothing can probably be made in most situations 100% safe, right? So think about it like that. So when I'm writing a document about safety and I'm talking about the cost of that safety, it's not that there's not a ledger somewhere where the company keeps track of the cost of processes and um, uh, and what that means to the cost of the product, but there's a sliding scale one that within reason makes sense. But you got to be careful how you talk about it. There was a long time ago now, it's hard to believe, there was the Peanut Corporation case where peanuts were contaminated. And then of course the peanuts are sent off to make peanut butter and that gets contaminated. Well, what sunk the executives of the company of the Peanut Corporation, which it was called in Atlanta, Georgia, is that they said, well, we can't afford to change or clean our machines or afford to address this in the way we need to because of the cost, because they'd have to recall product and things like that. Well, doing that immediately impugns your integrity, and probably should have in this case. And even though you might mean in a memo that making it 100% safe would triple the cost of the product, you can't talk in those terms necessarily, right? Everybody knows, and it's our job as lawyers, as trial lawyers, to explain to juries, the relative cost of safety, and that all products have, especially medical devices and drugs, depend on many things for its ultimate efficacy and safety. Could be the patient, especially with medicine, well, not all, but many medicines, including still antibiotics, kill people. That's just, everybody's different, and it depends on that. Depends on the people using the product, that is the surgeons, not to impugn providers at all, but everybody has different skill. There's different circumstances in which products are used. So that is even beyond what happened at the manufacturing level. So when we're trying to tell the company's story, if we have a document, so we're trying to get people to understand relative risk. And this is important. So when you're explaining to a jury risk, right, you're comparing it to driving, which is almost always more dangerous than most medicines or devices. And you're trying to explain all the clinical trials and all the things the company does to make sure a product is safe, all the regulations it follows, all the things a company may go beyond the regulations to make a product safe, especially in food safety. Regulations are sort of where you start, and then you have to, probably go well beyond that to truly have a safe place to produce food. And it's also true with clean rooms and other ways that healthcare products are produced. So you're trying to get the jury to appreciate the relative risk of things, and that medical devices are generally pretty safe. But if you get a couple of memos where people are saying, well, we can't do that because it costs too much, and it's not put into proper context and it's not explained correctly, then it makes the hill a lot higher to climb when defending the product and telling the company's story, which is almost always one of a tremendous care. And at least in my experience, I've always been very proud to be able to stand up for companies that make medical device products, even food products. Doesn't mean everything goes perfectly all the time, but generally the intent is that we took all reasonable safety precautions despite cost to make our product safe. And also, you're also trying to explain to people the cost of it not being. It's so prohibitive and it puts you out of business so fast that obviously most expenses are tolerated in developing the product. I just want to make sure I'm keeping track of questions here. If you have any, ask them on the way and I'll try to pick them up. But I will proceed. So what are bad document creation practices? Some of them are very obvious, but some of them sometimes are something that we can implement in our daily practice of communication. You know, we communicate a lot more than we used to, if that makes sense, right? I mean, before you email, you had to get up and go talk to somebody or write a memo. I mean, actual memo and not just an email. And you had to, or go talk to, or pick up the phone, right? So in any event, it's, and I'm sure lots of companies talk about this with their employees, but we're gonna talk about these rules, plus it leaves some room for some interesting stories that have occurred, most of them unpleasant when I face the documents in the context of a litigation, but in any event, it is what it is. So as I may have told you with this first, the Jailhouse Memo, I was reviewing, I was in a warehouse of 1 million documents for a medical device company. And I ran across a document with a person with sticking their head between bars. It's just handwritten, hand drawn, you know, picture of a person looking through bars. And it said something like, this is where we're all going to end up. And that was that person's attempt at humor about what that person thought of the company's context vis-a-vis this certain process within the development and sale of this medical device. And you couldn't have a more pejorative memo, right? And it's just a classic example of a person either making fun of something that shouldn't be made fun of, and that is patient safety, or actually serious, right? And thinks that there's criminal conduct going on. And most conduct in product liability cases and even False Claims Act cases do not raise to the level of a crime. They can, but generally it doesn't help though. I mean, what does it make the company's intent look like? If you employees, you know, you'll get that employee and you'll depose him. Why'd you draw a jailhouse? You know, and they'll try to pass it off as, well, I was just goofing off, right? But usually something prompts it. And this was in the context of a quality control step that they didn't think was appropriate, or was not. That's wrong. It wasn't that they didn't think it was appropriate. They didn't think it was there at all. So that's doesn't help. So it can raise the stakes fast from something that is already probably a very expensive product liability or fraud case or patent case, but usually with those kinds of things, it relates to the former two, and how that can impact people's perceptions of the company. So the next one's the Hangman Noose memo. This was in a different litigation. This had to do again with a medical device, and somebody was talking about regulators coming in to do an inspection. And it wasn't, there wasn't, before finding this memo, there wasn't a particular concern about, by the defense, that means our team and the company, about, boy, we don't think we're just completely frivolous when it comes to what the regulators will care about in terms of good manufacturing processes, documentation, clean rooms, all the things that go into an inspection. And of course, then we run into the Hangman's Noose memo, which is a person drawn with a hangsman noose around his neck like they're hanging. And it just, again, you completely paints, right? Of course, we have to go find the person. The person was not a manager, was a person who had just started out as being a quality control person and just, right, didn't use judgment but was upset about what was going on in terms of the quality control process, although they had walked into the middle of it when it was being developed and there were unanswered questions. So instead of asking questions, there's a document about, well, we should be doing this, and there's a hangman's noose was supposed to represent, on questioning later, patients being injured, right? So not very helpful, extreme, as a matter of fact. And then, so don't do that. The next one is a document that I had in a False Claims Act case. And in this case, it was a question of implementation of the compliance plan. So we were defending a case regarding, obviously, what the company or the healthcare company was doing in terms of compliance, and it was doing mostly good things. But this particular employee, excuse me, didn't think we were. And because of her view about a particular issue, it had to do with monitoring, and it wasn't perfect, but it was being addressed. Even long before somebody blew the whistle, long before that, was addressing it, but wrote this, if we don't correct this compliance and start plan and start monitoring it more closely, we'll have this will be a disaster of epic proportions. And of course, it's not good. I mean, her opinion's important, right? Nobody thinks that it wasn't important, but the characterization was way beyond what was happening in the context, and the person didn't understand that it was being addressed. In other words, the company was in the process of dealing with clearly a stale compliance plan that needed to be updated and monitored more often, and we're in the process of doing that. So instead of, again, writing this, instead of going, hey, you know what, I have a little concern about, when's the last time we actually looked at what the performance of this plan is and things like that. So, instead of asking that question and then finding out that, oh yeah, you're right, we need to update it, we need to monitor it, and we're in the process of doing that. You can help us with that by doing this. This gets written. So then of course, nobody knows about it or says anything about it until then there's a case to be dealt, a lawsuit to be dealt with because a whistleblower came forth. And so now you got this, she has to explain it. It's very uncomfortable for the witness, right? So the witness goes, it gets grilled by the prosecutor. And then, what were your concerns? And you were concerned enough to write this, weren't you? So it must have been you must have really thought that this was a problem for the company, right? Well, yeah, I did. And then we have to go back, and when we get to ask questions of the witness, we have to go back and do the rehab, right? And we have to say, well, but you didn't know that that the company was in fact working on this issue, and you later found out. As a matter of fact, you found out whatever the timing was, 2 weeks later, when that in fact there was a team working on this, and you just hadn't got incorporated into that process, so you have to do that. And it can help, but it's never as good as not having to deal with the matter at all. So that there's the cautionary tale of those that are all written either frivolously or without all the facts or an understanding of the context. And so if nothing else you take out of this, after the don't put safety in monetary terms rule, don't use apocalyptic language or gallows humor, literally. in memos, and most of you don't see it that often, but I'm always surprised when stuff comes up. Another problem with bad document creation is when we're upset, we don't wait to respond. Sometimes you might not be able to wait because there's an actual emergent issue, but rarely is that the case. In our law firm, we called it the 48-hour rule, and that is, I'm upset. I think this person misses the point, and I want to tell them that not only are they wrong, they are being rude or whatever. I mean, you're just mad about it, right? And the rule was just stop, right? Just stop and don't write anything until you think about it a while. You read the email a couple times, or understand if it wasn't an email, maybe somebody told you what was going on. Then it's, of course, how reliable is that? And just let it sit for a while. This may seem so basic, it's incredible, but it's just amazes me how people think they have to shoot off a response that is not only corrective, but offensive. And that's never helpful because everybody has emotions. Good employees have emotion. They care. So that's not the point, right? We don't want to be robots, but you got to take time, and it can eliminate um, a lot of bad documents if you just take that time and think about it. Unless it actually is an emergency, then address the actual problem, not what you think of the person, right? You can deal with what you think of the person later. Excuse me. So a corollary rule is probably one mistake we make, we write instead of talk. Back in earlier in my career the rule was walk down the hall and ask, hey, I got this email and can you explain it to me? And can we talk it through so I really understand what you meant? Or I got this email. This is really upsetting. I think it's wrong. Go find a confidant or somebody you can talk to say, hey, am I reading this right? And if you're not supposed to share it with that person, maybe just say, try to build some context around it verbally that's not recorded anywhere. Even a phone call, right? And don't leave a voice message. Voice messages are documents, ultimately. And talk to somebody and say, or the person who wrote it and say, geez, I just got this, and you're in the California office and they're in Minneapolis or whatever. And can we just walk through this so I understand what we're doing here? Because it seems like I don't quite understand it. And maybe if we do that and then deal with it that way. Again, maybe if you're really upset, waiting a while to do that, unless it has to be addressed immediately. So picking up the phone, going to somebody's office, if you're in that context and not working from home mostly, can be helpful. And writing an email that says, I'm not sure I understand what you're saying is not helpful sometimes. It just adds more, it heightens the scrutiny and the tension, right? Because the other person will read that like, this person thinks I'm an idiot, and instead of an actual honest inquiry, right? And so in writing an actual honest inquiry can take a long time because you're always asking persons to interpret it instead of if you're just talking to them on the phone or a Teams call or a Zoom call or whatever, then you can go through whatever the questions are raised by a particular email, document, report, or whatever it is, draft of a report, whatever that's creating the issue. A lot of people write things before they're sure they know what the facts are or they understand the facts. Again, a corollary rule of what we just talked about, right? I can't believe how many people, and I probably do. Matter of fact, I do it more often than I'm afraid to admit, even in personal communications. I misread things. I don't think about context or where it's coming from. I don't know all the facts. And sometimes I'll respond, even though the response is sort of innocuous and not a problem. So I shouldn't respond, right? I should say, let me think about this, or I'll get back to you, or can we talk about this? Or worse yet, you don't want to write reports that are going to be deemed as facts when they're not, when you're not sure about them. That should seem obvious, right? Especially in the scientific realm we operate in when we're talking about medical devices, food safety, whatever it is, drugs, clinical trials, whatever. You would think you would never write anything without really understanding the context, but that's something that's a problem. Finally, making conclusions without knowing the facts. Sometimes we just extrapolate too far, right? The conclusions that we make from A plus B are maybe easy to be C, but then beyond that, we don't have the facts, right? And what are facts, right? So we'll talk about that a little more, but is it something you actually know? And we'll talk about what knowing means in a minute. And are they actually facts? So when you get something, maybe a person you trust, they send you information, you go, well, it must be true. Do you know really that it is? So we tend to take things for granted sometimes, and lots of times you can. If you're dealing with a tight-knit team that's working on a specific problem, everybody's honest in it, and you can be quick and agile, and you don't have to worry about this. But sometimes that's not the case. So some other ones, poor nomenclature. I run into this a lot especially when we're evaluating testing to determine what caused a product to not perform as we hoped, or we're analyzing whether in light of what we've learned about that, there should be a recall. In light of something some employee said about the problem with the document or payment methods or things like that, where we think a problem's being raised, right? Well, we know a problem's being raised, but we tend to run right to things that in writing that say this is a super high risk, and if we have defective products, it would be unethical to have them on the market a minute longer because we could cause injury and it'd be our fault. Well, you might not even know what's going on yet, right? Or much more benign things. I've had documents which are analysis of what's going on from a research and development perspective about something that's happening in the field, where words are used such as failure and defective and things like that, where that's what we're trying to find out. We're not making any conclusions about that. Now, I understand the scientific proposition of testing things to failure, but that's a specific term of art in that context. That's not an adjective, right? Or something to describe a conclusion about what's going on, especially if we haven't reached that conclusion yet. So that happens a lot. Just the lesson there is just look at your language, right? And even though the inquiry might be around what you might characterize as failure or something like that, try to be a little careful about the language that goes back and forth between, say, clinicians in the company, patients in the company, regulators in the company, about how you describe things. Because while the two people talking might understand the language and the context within which it's written, other people later might not, and they'll just see bad words, right? Or bad in the context of a liability case or a fraud case or something like that. So that's the important thing there. Not paying attention to privilege or privacy or confidentiality in document retention rules. That is ignoring all the things we talked about last week, and you just make things public that shouldn't be, right? You're sharing it inappropriately. We talked about all that. I don't expect people ever do that hardly. intentionally, but they're just maybe not careful with what pathways through which they're communicating, or what devices they're using, or not taking the time to follow the company rules regarding those things. And that's a discipline issue that, again, when you're moving fast, is sometimes hard to follow or even learn if you're new to it. Being personal in a negative manner. It's one thing to say, great meeting today, it's great to talk to you, really brought some good ideas. While I didn't agree with some of them, but that's the kind of thinking we need, instead of course, I can't believe you raised that stuff. It seemed to be incredibly out of context and not helpful, and right, just impugning the person's integrity and intelligence or whatever. So we all know we should be respectful, and that's rule number one. It's really hard in trial to talk about intra-company squabbles where people are being personal. It's easy to talk about intercompany disagreements because they happen. That's how things push forward. You identify an issue, you talk about the issue, you file a pathway to a resolution of the issue. And even if you pick the wrong resolution, it might not be bad in a liability context, as long as it's well thought out, whatever it is, based on the science, and you deal with it. But things that are, it'll reflect very negatively on the company if there's not respect shown amongst employees, leadership, and whoever's involved. And then assuming your document is confidential, we talked about that. They're not, right? Somebody's gonna someday read them. If they don't, you're lucky. So those are bad practices in document creation and conduct. And again, I want to emphasize the writing is conduct, right? It's not just writing. So what are good habits? What are things you should do to make sure when you communicate within the company, you're doing it in a way that reflects well on the company and gets the job done? I mean, that's why people call the lawyers the no department, or the get nothing done department, or the no sales department. Well, we actually are trying to create, at least in this context, document regime that hopefully makes things more efficient and keeps people focused on what's at hand. And what's at hand, it's doing business, helping people, and making a profit. So the first one is the communication necessary, i.e. does it meet a business need? A business need can be, we should get together for lunch. That's a business need. You need to create teams. You need to create, a good working environment. So I'm not trying to suggest that if it's not about a quality control person, or a quality control issue, or a legal issue, or a accounting issue, or a sales issue, or marketing, that doesn't mean it's still not meeting a business need. It could be planning a birthday gathering in the office or something. Those are business needs. You live in a community of humans. You don't have to dehumanize it to make it still be a business need. But business needs might not be, I went out with my buddies last night, we got really hammered, so I'm moving kind of slow today. Maybe not necessary to even talk about why you're tired. You could talk about it, but don't write about it. How's that? Maybe a better way to look at it. Accuracy is always important. Is it true, and is it a fair reflection on what happened, the people involved, and things like that? It's amazing what people will write and they don't know whether it's true or not, or they go beyond to speculate, right? They've written what's true, excuse me, without being prompted. They say more than they need to say. So it's important to write what's accurate and not create a world, an imaginary world of what might have happened by speculating about things. We already talked about be appropriate, be aware of humor and sarcasm and inflammatory opinions. You can have strong opinions, right? It's good to have them. You should care, but be careful how you go about that, right? I'm really upset that this is happening and I want to talk to somebody about it instead of just ripping off a long email about all the things that are wrong. Go talk to somebody about it first. And in most companies, there's a recordable, proper way to get those issues fleshed out, heard first, and then fleshed out. Be understandable, use plain language, and include important context. So this is more flesh on the be true and fair and concise. It's, don't try to sound too intellectual. Don't use pejorative language or language that people wouldn't understand, or culturally insensitive language. And that can be culturally young, old, race, not race, gender, whatever. Just don't. Unless it's a specific subject matter of an issue like clinical trials. Well, it'd be nice to have more of these people in because it'll be better. We'll give a more a better understanding of the medicine's use over different types of people or something like that. That's different. So anyway, make communication as simple as possible and easy for people to understand. Be succinct and do not include extraneous information that may be confusing to later readers. I already talked about that. I don't need to say anything more about that than I've already said. Deliver it correctly only to those who need the communication. In other words, you got to think about who needs to hear what you have to hear, right? Sometimes most of the time, that's probably very straightforward. You have a group of people you're working on a project with, or a particular issue, or you're getting ready for an inspection and you have a team that does that, or whatever it might be. So it's pretty clear, but don't include people that don't need to know. They might not know what to do with the information. They might pass on the information. They might, and further miscommunicate the information if they don't understand all the things we just talked about, being succinct and concise. And if they don't have context because they haven't been part of the sort of ongoing issue that's the subject of the communication, then why do they need to know? So there are reporting lines. I understand that. You have to follow those. So you may be sending the communications up the chain because they need to be, because even though that person might not be working with you on a daily basis on what you're working on, they still need to have the communication because it's a marker of where you are, and so they can weigh in on progress, whatever you're working on. So that is the make sure it's delivered correctly, and also the right addresses, the right machines, the right things. It's all done on business platforms that relate to the business and not outside them. Yeah, do not use personal accounts. We already talked about. Do not write what you don't understand or disagree with. I should clarify that. So if you disagree with things, you can write about it, obviously. But if you don't understand it first, before you disagree, that would be a clearer way to state that, and I apologize. But yeah, so if you don't really understand it and you're not sure, don't send off a response other than if it's, God, we should talk about this. I'm not quite sure what you mean by these things. And, when we meet on Tuesday, I'd like to go through that. And if you want to talk sooner, give me a call, whatever, that's fine. But just don't say you disagree if you're not sure what you're disagreeing with. So that's the lesson there. If you feel uneasy, do not write. So if you're going, oh my God, I'm not sure how this person's going to take this, and I'm not really 100% sure if I understand, or this is really serious, right? Suddenly we're in a place I didn't think we would be in terms of what I view as how the company's conducting itself, or at least not the company, but the people, whom you heard the news that makes you upset or uneasy. Don't write. Go talk to somebody. Go find out. Let's think about it for a while. My spouse, who investigates employment claims and runs into conduct that you wouldn't believe, you think this stuff might be fanciful. Her world is unbelievable. And in any event, it's a tummy test, she calls it. Just don't write. Wait a while. And if it's something that's emergent, call your manager. Boy, I just got this, and it looks like we're going to be doing this, and that really, it's not what we talked about. That's not really consistent with the whatever plans in place or process. And talk to that person verbally, on the phone or whatever, and say, am I reading this right? Do I have this right? Or, I want to understand this. So anyway, stick to the facts. So this is what I want to talk about in terms of what knowledge and facts mean. Imagine you are being deposed. What do you really know? So when I talk to people of getting ready for depositions, we talk about, well, what if I don't remember, they say, and I go, you remember things differently every time you remember them. It's just the way the mind works. That's why eyewitness testimony is notoriously a problem. So you got to be careful about your memory of a conversation or what somebody told you 3 days ago or whatever it is. So that's memory. The other part is knowledge. What do I really know? In other words, did I see it, smell it, hear it myself? Was it directed to me? I mean, how do I know it? Sometimes it might be, I read it in a document. I know what was written in the document. That's true. I can read that and it says whatever it says. But do I really know what it means? So when we talk about knowledge in the context of a deposition, we're talking about, is it your personal information that you know directly? So, that's a concept in fraud and whether you're involved or not involved and whether the information is useful for whistleblower purposes or not is how you know it. Were you involved in it? So before you pass on information, right, how do I know this? You need to ask yourself, and do I know it? Or did I just hear it from people? And I'm not sure about the context. And so I didn't see that report. I didn't see that happening in the manufacturing process. Or maybe you did. So then you do know it. But that's an important concept that I think people lose sight of is what do they really know before they start writing things down. And half of it turns out to be sort of accurate, but not quite in context. And then it has to be unwound. And I don't think that advances people's or the company's business's goals very well if you're dealing and people communicating about things they don't really know about and reporting about it or complaining about it or whatever. Doesn't mean you shouldn't raise complaints. You should always raise complaints because they're important to work out, but it's how you do it that we're talking about here. So here's the last one's really important that companies do badly. That is appropriately responding to complaints and recording what that response was. So lots of companies hear a concern of an employee and they're very concerned about that employee's observations or whatever it is. And they take it seriously and they talk to the person and interview them and say, oh my gosh, what's going on here? We really want to know what's happening. And so we want to develop a plan for addressing it. And you can help us, right? Because we have to have a plan that addresses the specific problems and the facts that are on the ground. And they do all that right, but they don't record sometimes exactly what they did. they don't write back to the employee and say, we talked to you, and as a result of that discussion, we talked to some other people. We came up with this plan. Here is the plan. The plan is to do X, Y, Z to address your concerns. And now you have a writing that says, we heard you, we gathered information, we came up with a solution. We reported back to the person. That person said, boy, that's great, right? And if they didn't respond, you might want to call them and say, you okay with this, right? Now you can't coddle every complaint. You can't, right? You have to pick and choose sometimes, depending on what's actually important. But most companies want to hear from their employees, want to address concerns. And the problem is they don't record it. So a good document practice is take credit for what you've resolved. And that really looks great when you're dealing with with the documents and litigation. All right, last thing quick, and then I'll look for questions. If you can't, if you're not sure who to talk to, make sure you know, there's lots of options, hopefully in companies. Is there a manager you can talk to about a concern you have, or document that you received or something? Legal department, you know, maybe they have a person you can talk to and say, geez, you know, I got this complaint from a line manager and this is really concerning. I have no idea if it's true. How should I proceed? And then you probably hopefully get some direction about that. Get a manager involved. You know, let's address what's going on here, what this person observed, what we can do about it. Sometimes there's designated reportees or ombudsman or people you can just write to, or hopefully not write, but talk to and say, boy, I think this is going on. I've observed this. And they're sort of anonymous, right? And they're going to keep your name anonymous. So that's one option, right? So, you know, I tell you not to write things down, but you have to also have a way to report things. There's whistleblower options. Well, hopefully you're not a whistleblower yet because you're just trying to figure out what you just read, what you just saw, or whatever that. Or there may be a trusted confidant that you can talk to, right? Somebody that you work with and you go, geez, you know, I didn't want to respond to this email, but this is really concerning to me. And maybe that person just sort of fleshing it out with them, unless it's privileged or confidential, or would, you know, obviously give up information about a person you shouldn't, then you shouldn't do. And then there might be company policies that address all these possible avenues for reporting and discussing issues. And hopefully those policies are helpful. So that's all I have. We only got 3 minutes left, so if you have questions, you can put, I don't see any questions in the question box on my machine. I don't know, Charlie, I don't know if you have any.
I do not see any, no.
Okay, all right. I just wanted to double check because we weren't sure if the presenter was giving them or getting them the questions or not. But anyway, hearing none, we're going to be done 2 minutes early. I appreciate you taking the time. If you have questions about any of this stuff we've discussed, because I know it's been a lot, and especially on the first session, a lot of broad brush concepts about sort of complicated things like privacy and confidentiality and privilege and things like that, give us a call. We're a resource for that very purpose. That's what we do. So thank you very much and have a great day.